Okay, what's up? We're going to take a look at question 6 from 2004 July. It's the Torts questions, and it tests on some unusual issues. And yes, the bar exam used to have 6 questions. In fact, back in the 60s and 70s, used to have 15 essays. Believe that. So things change over time. All right, let's take a look at this essay. Again, very unique issues, and I think it's a good one to look at because the examiners can do pretty much a wide spectrum of things, although with most essay subjects, they kind of test very narrow issues, except for torts and common law. They seem to be pretty broad. All right, so let's take a look at the call of the question. As always, we want to go to the call of the question first, and you do this on the bar exam and everything. So number 1, what claims may Melinda assert against Wilbur, and what damages, if any, will she recover? So they're asking about claims and damages. So you want to make sure to understand that because the damages play a factor in something that comes on in this fact pattern. So Melinda versus Wilbur. And let's go to number 2. What claims may Jack assert against lawyer, and what damages may he recover? So same call to question, Jack versus lawyer. All right, so we got pretty interesting parties, no P and D, which is generally what the examiners do for torts, like plaintiff and defendant. They'll do Paul and Dan or something like that. But here we got L for lawyer. I don't know what the J stands for, but I think you'll see there's actually a reason why we have W and M. Okay, let's take it from the top. Again, you always want to read the fact pattern several times to really understand it. First thing is Jack owned the world's largest uncut diamond, the star, worth about 1 million uncut, 3 million if cut into finished gems. Well, thinking about that logically, it's like, well, let's get it cut into gems. I mean, why not make it 3 times more valuable? Of the 20 master diamond cutters in the world, 19 declined to undertake the task because of the degree of difficulty. What that means is, okay, they're master diamond cutters. These are experts. These are the world's leading experts. And 19 of them refused to undertake this task, even if they were getting paid, because they don't think that it's possible, that, hey, the degree of difficulty is too much. You'll never get this done. So 95% of the world's experts have agreed this is not possible. Keep that in mind because it goes to damages. Don't forget, in torts, preponderance of the evidence is the standard. That's 51%. They're never going to get that with the 95% of the people saying, no, it can't be done. It goes to damages, you'll see. And this is why it's important to read facts carefully. Dates, numbers, amounts, quotes, things that are put in indentations are extremely important on the essay and the MBE section of the bar exam. So pay attention to that and descriptive language. There's a reason why the examiners do it. I'm telling you, this exam is so much more than just memorizing law. It has actually nothing to do with that. It has to do with like reading carefully and understanding factual situations. Okay. One mistake would shatter the star into worthless fragments. Okay, so the star is pretty much only going to be worth 1 million because in order to cut it into finished gems, 95% of the experts say, no, you're going to end up making it worth nothing. So probably just keep the million and move on. One master diamond cutter, Chip, and notice Chip is not in the fact pattern, which is interesting, studied the star and agreed with Jack. Okay, so Jack's the guy here. So we got a lot of different parties here, and it's really important to, like, again, if you're not reading carefully, if you're not paying attention to who's who, you're going to get lost. All right, so agreed with Jack. Finally, there's Jack. In writing to cut the star for $100,000, payable upon successful completion. Okay, upon successful completion. If this was a contracts essay, it seemed to me that'd be an express condition. And it wouldn't be construed as a promise. It's like, if you don't successfully cut this, you're not going to get paid anything. So there's a 95% chance Jack's not going to get paid. As Chip was crossing the street to enter Jack's premises to cut the star, we don't have Chip up here, which is interesting. But you'll see who Chip is. You'll see in a second. I'll show you. Chip was knocked down by a slow-moving car by Wilbur. Okay, so Wilbur's the driver. And since the bar exam is now pretty much moved completely online, with rare exceptions, it's going to be hard to take notes like this. And that's something that we're going to have to adjust to as the future comes, as we move on into the future of technology. But for now, we're going to have to demonstrate it like this. All right, so Wilbur's the driver, and there we go. Jack is the cutter. All right. I'm sorry, no, Jack's not the, yeah, Jack is the cutter. And Chip's the owner of it. So, slow-moving car driven by Wilbur. Wilbur has driven through a red light, negligence per se right there. Clearly, when you violate a criminal statute, yes, it is a criminal statute, that brings negligence per se. So negligence per se satisfies duty in breach, which means, and there's a presumption that, of that, because you actually sometimes you can violate the statute and be excused in rare situations. Not really tested on the essays, definitely tested on the MBE. So here we go. We have running a red light, did not see Chip, who was crossing with the light. So clearly Wilbur's in the wrong. Chip suffered a gash on his leg, which bled profusely. So he's hit, he's got damages, clearly he's going to be able to recover damages. But again, Chip is not in the call of the question, so you have to be sitting there wondering, well, why are they talking about Chip? You'll see. Though an ordinary person would have recovered easily, Chip was a hemophiliac and died as a result of the injury. So Chip is dead. That's why he's not a plaintiff, because a claim is being brought on his behalf, likely by his estate or a beneficiary of his estate or someone that the law allows you to bring a claim on behalf. So he's dead, which to me says this is a wrongful death case. And with wrongful death, you're going to have survival action. Survival action and wrongful death are rarely tested on torts essays, and even almost rarely tested on the MBE, but it's just a negligence case with different types of damages, essentially. Chip left the widow, Melinda. So essentially, that's Chip. Melinda is Chip. So he's suing Wilbur's the driver. That makes sense. So the claims are pretty much derivative. All right. And we'll get to that in a second. So Jack, so like I said, we have wrongful death because he's dead. And there's no right order to put this in. I so dislike when students mention, like, it's my organization, or they say ridiculous things like, it's my writing. What, you don't know how to write a sentence? No, it's the fact that you just don't know it. You don't know how to apply the facts to the law. That's as simple as that. You either know it or you don't. There is no two ways about it with any subject, with any essay, with any diagnosis. You either know it or you don't. So wrongful death, and you have to apply the law to the facts correctly. So he's cleared. Clearly, it's just a negligence action. So you're going to obviously bring up negligence. And when you have wrongful death, again, we're going to have a survival action. And it does not matter which order you put these in. I don't care if you go negligence first, wrongful death, survival action. And we also know that this is his wife. So we have loss of consortium. And loss of consortium is for services, society, comfort, sexuality. So I think they pay by the inch, ladies, so you might want to get somebody worthwhile. So we have loss of consortium for damage, because we're going to have to talk about damages here in a second. Okay, where are we at? Okay, so that goes there with, that's pretty much what I see right now. Like negligence is the main one, because these are all essentially negligence. So what is wrongful death? That means certain beneficiaries of your estate, usually just limited to spouses and I think children. I know loss of consortium is pretty much limited to spouses. There's a ton of mix in different jurisdictions. There's different laws in every jurisdiction, but I think a majority of it is, you want to check the answer just for clarity, is for loss of consortium. I think that goes for spouses. Survival actions, there's survival actions and wrongful death have like different beneficiaries, but they're very similar. So let's just say I'm struggling to figure out which one it is. Wrongful death, I believe, can be brought on behalf of the estate. Actually, and that seems to be also, so this would be a spouse. And survival action is pretty much, it's the amount of damages measured by the time the injury occurred till the time of death. Usually like Chip's lost wages. Let's say that you're in the hospital for 6 months in intensive care and then they finally pull the plug. Those 6 months you didn't work, those 6 months you have hospital bills, those are stuff that can be recovered in a survival action. Wrongful death is likely going to recover damages for future earnings, for anything that you would have earned down the road. If you're a lawyer, the best kind of case you can get as a personal injury attorney is for like an MBA team plane to go down and handle that, because the amount of damages for that are astronomical, and that'd be the best type of case you could ever get. Loss of consortium, again, sex, society, comfort, and that generally goes to the spouse. So we have the estate here. Survival action is Chip's damages between the time he got injured, and it looks like he died pretty quick. He died out as a hemophiliac. He bled out. So any kind of like damages for his pain and suffering during that time, okay? So that's how and because they're asking about damages, so that's why I'm covering this in such detail, is because of that. And yeah, sure, there's a possibility that since these are such rare issues, most people don't know them. That's why we're covering it right now. Okay, moving on. Jack, who still has the uncut star, engaged lawyer to sue Wilbur in negligence for the $2 million difference between the value of the diamond as cut and as uncut. Lawyer allowed the applicable statute of limitations to expire without filing suit. Okay, so Jack's the cutter, lawyer's there. So he's suing for malpractice, and for malpractice, it's two standards. First of all, you have to fall below the standard of care. The lawyer's conduct has to fall below the standard of care. There are two types of professional malpractice, the bar exam tests. The first one would be lawyer malpractice, the other one would be medical malpractice. Fall below the standard of care, and clearly any reasonable lawyer would have filed within the statute of limitations. That is really not the issue. The issue is, in order to prevail, Jack must show that he would have won the suit against Wilbur. So essentially, Jack versus lawyer is Jack versus Wilbur. That's called, with lawyer malpractice, the case within the case. In order to win, so the lawyer's conduct fell below the standard of care. That's not an issue. Got that. Two elements. So we check this one off. The second one is Jack must prove that he would have won his case against Wilbur in order to prevail against lawyer. And we know that's not going to happen for two reasons. Number one, first of all, how does Wilbur owe him a duty of care? Wilbur hit Chip. Chip and Jack have nothing but a contractual relationship. So you're one of my students. If I got ran over by a car and I got killed, you're not going to be able to sue the driver. So, I think there's a lack of duty there. I don't think the duty extends that far because they're not a foreseeable plaintiff. They're not even anywhere near the zone of danger. And more importantly, is Jack suffered no personal injury or property damage. He only has pure economic loss. Don't forget, Jack's economic loss is the $100,000 for successful completion, which there's a 95% chance that's not going to happen. So he's not going to end up being able to successfully do that. Where's the 95% go? That goes to something else as well. Oh yeah, for the, I think Melinda, let me see something else here. We're going to get there in a second. All right. So the lawyer, we got that. So what claims may Linda assert against Wilbur, and what claims may Jack assert against lawyer? So the claims that, again, we have the survival action. We got the wrongful death. Of course, they're just essentially negligence actions. And with negligence, because we have the breach of the statute, we have negligence per se. By the way, you can do one of two things with negligence per se, because negligence per se essentially covers duty and breach. By violating the statute, the criminal statute, you've essentially breached your duty of care. So that covers duty and breach. But because you also failed to act like a reasonable person, there's also that breach too. So if you can't get it on the statute, you can get it on duty and breach. Do you have to do both? Not necessarily, but you might as well. So they're kind of two separate things, but negligence per se would cover duty and breach. So you really didn't have to go into that if you didn't want to, or if you were short on time for whatever reason. Now, one of the things too about the negligence action is one of her damages, besides for she's probably going to sue for loss of future earnings. And that's going to go in under wrongful death or whatever, loss of future earnings, because that's going to be one of the types of damages. Well, Chip's future earnings was going to be, was about the star. That, hey, if I would have had this, I'm sorry, Jack is not the cutter. Jack's the owner of the star. Excuse me like that. Chip was the cutter. I knew I messed up on something. Excuse me about that. So Chip's the cutter. So his wife is going to say, hey, look, he was going to make $100,000 based on, like I said, like it's what the damage is for wrongful death. He was going to make $100,000 because he was going to cut this diamond. Well, it was only payable upon successful completion. And since 95% of the experts said that there's no way this can be done or it's too difficult, there's a 95% chance this wouldn't have been done and he wouldn't have gotten paid. So that would not be included. The $100,000 would not be included because it would be hard for Melinda to show by a preponderance of the evidence, 51%, that it would have been successfully done because 95% of the experts would testify it can't be done. And we'll never know now because, I mean, I guess we could. He could still cut it, but, and Jack was the owner of the diamond, excuse me. So it was Chip, the cutter. I got it mixed up, and that kind of actually changed a little bit of things. A little embarrassing on that one. So Jack, who is the owner of the diamond, he only suffered pure economic loss because the only thing he really lost by Chip getting killed was the possibility that he would have made money because Chip would have cut it correctly, which again, pure economic loss. If anything, he would have a breach of contract claim against his lawyer. But Jack clearly has no claim against Wilbur. All right, so there you go. That's a wrap. Again, like even I mixed up the parties, and I know this essay, so I can imagine how hard it is on the bar exam for you to like stay calm. I mean, it's not that hard to stay calm, but make sure you stay calm. And if you make mistakes, you're going to make mistakes. It's okay. That's why you read it several times. And again, if I would have read it a second time by doing this, I would clearly pick that up, and I got it at the end. And that's going to happen. That's why you do the setup now before you start writing. Because if you start writing and start going nuts on the keyboard before you had a chance to process it and think it, you're going to start going down the wrong path. You're going to end up spending more time with the wrong analysis than if you spend an extra 5 minutes setting it up the right way. All right, that's a wrap for question 2004 July Torts, question 6.